Okay folks, let's get started. In this video topic, I'm going to review the expansive qualities of the felony murder rule and some of the most common limits that state courts and a few state legislatures have imposed on the felony murder rule. So at common law, this was an expansive rule. Let's start with the classic case. You imagine a robbery when you think of felony murder. And so let's imagine that Fred decides he's going to use a toy pistol and he's going to engage in an armed robbery. Somebody unknown to Fred switches the toy for a real handgun, and so he comes into the store, and he's waving this gun around, and it turns out it goes off. He kills somebody during the robbery. It might be the intended victim of the robbery. It might be some other bystander. That death is going to qualify as felony murder, and most states are going to treat that as one route to proving first-degree murder. Now, the felony murder rule covers way more than this classic scenario. So let's consider first what crimes are covered. Suppose first that the robbery fails. So Fred comes in and he tries to carry out the robbery, but he never obtains any property before killing somebody and running away. Is that covered? Yep. Suppose Fred comes to the office and his plan is not to rob the place, but he's planning to defraud someone. He plans to try to convince somebody to cash a forged check. He happens to have a gun on him. It accidentally goes off. It kills the intended victim of his fraud. Is that covered at common law? Yep. Traditionally, what we call the predicate felony, that is the underlying felony that ends up producing the death. The predicate felony can be any felony traditionally, and it can include any attempted felony. So how about the who question? Well, who can be the killer? It could be Fred, as we've seen. But let's suppose that Lynn comes along with Fred, and the two of them are going to carry out their robbery with let's say, a toy pistol. In that setting, if Lynn shoots somebody, kills, let's say, a bystander, can Fred be charged with the death of bystander 2? Yep. How about if bystander 2 kills the victim as they're trying to resist the robbery by Fred and Lynn? Can Fred be charged with the death of victim even though it was a bystander who caused the death, who actually pulled the trigger? Yep, at least traditionally, that's covered. How about if one of the bystanders, say it's a security guard, returns fire or opens fire first, trying to resist the robbery, and kills Lynn? Can Fred be charged for felony murder for Lynn's death, his accomplice's death? Check. That's covered as well. How about the questions of where and when? Does Fred actually have to be in the room when the death happens? So let's suppose now that Fred and Lynn carry out their robbery. While they're there, they make everybody get on the floor, high-stress situation, and then they leave. Fred, lingers behind to wave his gun around and threaten people on the way out. And then 20 minutes later, the victim, who had a heart condition, was stressed out by the whole robbery thing, drops dead of a heart attack caused by the stress of the robbery. Felony murder? Yep. Where Fred and Lynn are out driving around and they're being chased in a high-speed chase, trying to get away from the robbery scene, and they hit and kill somebody in their car as they're running away. Again, that's covered. So this is covering lots of territory. Now, if you really pushed hard on this doctrine, it could become the exception that consumes all the rules. The monster that ate Hollywood, the monster that eats murder doctrine. That is, every murder could become first-degree murder. You would never bother gradations of murder. You wouldn't bother with manslaughter or second degree, because all of them ultimately could become felony murder. So all the states, to some degree or another, have limited the most expansive readings of the felony murder rule. So first of all, we could think about the restrictions on what can be a predicate felony. Very often what you see is a statutory listing of the qualifying crimes. So for instance, Kansas has a list that would include, arson and armed robbery and crimes that very often are associated with deaths. Once you get into this, people die. So statutory listings is a real possibility. Sometimes you'll have a statutory list and then it's supplemented by some catch-all phrase, as in North Carolina. It lists several crimes like arson and so forth, and then it also says any other felony committed with a dangerous weapon. You could have no list at all, but just a generic category, such as some, quote, inherently dangerous felony, or the Texas Penal Code talks about there being an act that has to be, quote, clearly dangerous to human life that causes the death. So those are some of the limits on what. In addition, there's the famous merger rule that says that a felony merges into felony murder and can't qualify as the predicate felony if it is a, quote, integral part of the killing and not independent of the killing. The classic example here is assault. If you've got an assault and it's the assault that causes the death, you can't treat the assault as a separate felony that led to the death. And so this is sometimes called the part-and-parcel rule. If the assault or some other felony is part and parcel of the death, then it can't count as a predicate felony. On the other hand, there are some exceptions to this. So if you have two distinct assaults, for instance, a non-fatal blow with a machete followed by strangulation, there's a famous North Carolina case here, State v. Carroll from 2002, that would give you felony murder because one of the two assaults is not part and parcel of the killing. There are also limits on the punishment levels. So in a lot of places, if you've got the enumerated felonies, those would qualify as first-degree murder for felony murder purposes, and then anything that falls within the generic, inherently dangerous felony catch-all category would be slotted into second-degree murder. Or, for instance, in Pennsylvania, all the felony murder convictions are slotted into second-degree murder, some lesser punishment. So those are some of the limits on what can qualify as a predicate felony. In addition, there are some limits that states create on who can be the killer and who can be killed and still count as a victim of a felony murder. It's common to limit the eligible killers to the defendant and his or her accomplices. If somebody kills while resisting the felony, it doesn't count. So if there's that security guard who shows up in the room to resist the robbery, then that person returns fire and kills somebody in the room, it doesn't matter who, then that security guard killing somebody doesn't count. This is sometimes called the agency theory, because the idea is the defendant is only responsible for his or her own killings plus the actions of the agents of that defendant. Less commonly, a state might limit who counts as a victim of a felony murder, and so you might exclude the death of accomplices. If the security guard returns fire and kills Lynn, in these states you couldn't hold Fred responsible. Finally, there are only modest limits that courts place on on why the death happens or where and when it happens in relation to the predicate felony. On the why question, courts commonly require that the killing happen, quote, in furtherance of the predicate felony. This is sometimes called the res gestae requirement. The killing must happen within the res gestae of the things to be done to commit the felony. As for the when and where limits, again, not many of these out there. They're proposed all the time, but they're not accepted very often by the courts. But some courts have said that the death has to be foreseeable. And the further apart in time and in place the death is from the actual commission of the felony, the more likely it is a court will declare that wasn't foreseeable. So you might end up with a Rube Goldberg type situation, such as we've got pictured here, and there a court might say that this death doesn't count as part of the felony itself. Any death that falls within the same continuous transaction as the felony is going to count. So that's true even if the death came before the felony, at least in some jurisdictions, or even before the defendant formed the intent to commit the felony. So one famous example from North Carolina is State v. James from 1995, where the defendant killed a person in their home. It was a mobile home, goes away, comes back and decides to burn the home to destroy the evidence. And so the prosecution successfully made this a felony murder case linked to the arson that happened after the death. So there's a lot of variety among the states. The best guidance I can give you is to assume at least some retreat from the broadest reach of the common law felony murder rule. And with that guidance in mind, do your research. We'll talk later.